Hello friends, in the series on the income tax cases, today we will discuss a very important issue that whether a belated return which has been filed by the assessee under section 139 subsection 4 can be revised under section 139 subsection 5 if the time permits. This issue has come before the Honorable Mumbai ITAT F bench in the case of Income Tax Officer versus VIKUNJ Enterprises Private Limited, and this issue has been decided on 30th April 2019. In the present case, the relevant assessment year is 2014-15. The assessee has filed its return of income belatedly under section 139 subsection 4, which talks about the belated return, on 16th February 2015 by declaring an income of 1.28 crore. Actually, there was no income for the assessment year 14-15, but due to some punching error, the assessee put the amount of 1.28 crore in the income column. The assessee realized this mistake on the next day, and on the next day itself, the assessee filed its revised return under section 139 subsection 5 by declaring the nil income. Now, what is important in this case is that if we see section 139 subsection 5, section 139 subsection 5 has been amended from 1st April 2017. Before that, section 139 subsection 5 says that the return can be revised only if the original return is being filed under section 139 subsection 5 or in response to notice under section 142 subsection 1. Since in the present case the assessee has not filed the return under section 139 subsection 1, that was clear because it was belated return, nor the assessee has filed its income tax return in response to the notice under section 142 subsection 1. The assessee has filed the return under section 139 subsection 4. So the learned assessing officer, relying on the literal interpretation of section 139 subsection 5, treated the belated return and did not accept the return which was filed under section 139 subsection 5, that was revised return which was showing nil income, because it was the viewpoint of the learned assessing officer that section 139 subsection 5 did not permit the assessee to file the revised return which is belated return. So he accordingly made the addition. When this matter came to the CIT Appeal, CIT Appeal said that the learned assessing officer didn't question the correctness of the revised return. CIT Appeal said that whenever the assessment proceedings are going on, it should be kept in mind that substantial justice should be done by ignoring pedantic and technical reasons, and only the correct income of the assessee should be calculated. Friends, this is a very welcome viewpoint of Honorable CIT Appeal, because nowadays whatever the judgments are coming from the CIT Appeals, they are behaving like second assessing officer, and even in the cases where there is justified reasons for giving the relief to the assessee, the CIT Appeal orders are more or less like the assessment orders. But this is a very welcome judgment from the CIT Appeal by taking the concept of section 4 and article 265 of the Constitution of India, which says that only the real income should be taxed. CIT Appeal also relied on 3 judgments: Mit Mohan Singh Kahlon versus Deputy CIT 2013, CIT versus VMR P Firm 1965, which is reported in 56 ITR page number 67. This case is decided by the Honorable Supreme Court, and CIT Appeal also relied on the case of CIT versus Ahmedabad Kesar E-Hind Mills Company Limited of 1981, which was reported in 128 ITR 46 Gujarat. The department took this matter to the ITAT and ITAT also upheld the order of the CIT Appeal. Now what is important in this case is that after 31st March 2017, section 139 subsection 5 has been amended, and now as on date, section 139 subsection 5 says that the return which is filed under section 139 subsection 1 and the return which is filed under section 139 subsection 4 can be revised. Earlier this was that the return which was filed under section 139 subsection 1 or the return in response to the notice under section 142 subsection 1 can only be revised. At the end of this video, once again I am repeating the name of the case. The name of the case is Income Tax Officer versus VIKUNJ Enterprises Private Limited, and this case has been reported in 109 ITR Tribunal, page number 517. The matter has been decided by Mumbai ITAT F bench and the date of the judgment is 30th April 2019.